You'd be shocked how many California entrepreneurs leave their business completely exposed because they never put 5 essential documents in place or never update them as their business and life evolves. Maybe you're one of them. You have built a successful company and you have got a family to protect. But when it comes to estate planning, it is always, I will deal with it at a later time. I'm Ali Talai, a California trust and asset protection planning attorney, and in this video, I will walk you through the 5 estate planning documents every California business owner needs so you don't leave your assets, your company, or your family vulnerable to probate, court intervention, or unnecessary disruption. Stick around and you will walk away knowing exactly what to sign, why it matters, and how to protect everything you have built. Let's start with the backbone of estate planning for any California entrepreneur, the Revocable Living Trust. If you run a business here, this is probably the most important document you can have. In California, if you pass away with more than $208,850 in assets under your personal name, your estate goes to probate court if you don't have a trust. It is worth noting that Assembly Bill 2016, which became effective April 1st, 2025, also expanded and simplified transfer options for certain assets like your primary residence, valued up to $750,000 without a full probate in specific situations. But a living trust still avoids the process altogether, regardless of value, and provides continuity and privacy that these new expansions don't match. Probate isn't just a hassle, it's expensive, public, and slow, very slow. I have seen this play out many times. One situation involved a business owner who owned 2 coffee shops in San Diego. He relied, unfortunately, on a simple will, assuming it was good enough. When he passed, his family spent more than 18 months in the probate court. Business accounts were frozen, the court controlled timing, and tens of thousands of dollars were lost to legal fees and disruption. If the assets had been placed in a revocable living trust, his family could have accessed those accounts in days instead of months. The trust allows business interests, real estate, and investment accounts to pass privately and efficiently without any court supervision. And for entrepreneurs, this isn't just about death. A trust also allows someone you chose to step in if you become mentally incapacitated, avoiding conservatorship and keeping the business running without interruption. Because the trust is revocable, that would mean you can update it as your business grows, your partner changes, or your life evolves. Most importantly, you decide who takes over, not a judge who doesn't know your business at all. And one more thing entrepreneurs don't realize, the revocable trust isn't just about avoiding probate, it's a platform for a much smarter planning. For example, instead of leaving assets outright to your kids, your trust can create inheritance trusts that keep what the kids receive, protected from their future creditors, divorces, and lawsuits. And for married couples, the subtrusts that kick in after the first spouse dies can be drafted with built-in tax flexibility, including provisions that may help optimize step-up in basis at the second death in the right situation. In more advanced cases, some clients also use trust design to improve ongoing income tax results depending on the assets and the family's situation. Next is the durable power of attorney. This document answers a simple but critical question. If you cannot act, who's going to act on your behalf? I once worked with a tech founder in Palo Alto who suffered a bad stroke. I believe he was 48. No one else could sign any checks, access accounts, or approve payments. payroll was almost missed, and a key contractor nearly walked away. A properly drafted, durable power of attorney allows a trusted person to manage finances, pay vendors, sign contracts, and handle ownership interests while you recover. In California, your power of attorney should be broad enough to handle real-world business needs, LLCs, corporations, banking, but tailored so it works smoothly with your operating agreement and other business documents. One important thing, banks are usually picky, so outdated and generic powers of attorneys are often rejected. This is not the type of document that you want to download from an online source. It needs to be current, and particularly it needs to be California compliant. This isn't about the business mechanics. It's about you. If you are injured or seriously ill, who speaks to the doctors? Who makes medical decisions for you? Without this document, families often disagree, stress escalates, and courts sometimes have to get involved. I've seen situations where medical uncertainty stalled businesses for months because no one had the authority to act while the business bills piled up and partners waited around. California law allows you to name a healthcare agent and clearly state your wishes regarding treatment, life support, and end-of-life care. The clarity reduces conflict, protects your dignity, and keeps everything else from grinding to a halt. You gotta make sure that this document is properly signed, witnessed, or notarized and accessible. There's no point of having a power of attorney or medical power of attorney, but nobody can access the form. Silence creates chaos, but clarity creates stability. Document 4 is the pour-over will, and you might be thinking, if I have a trust, why do I still need a will? And the answer is simple, and that's because sometimes we miss assets. We don't transfer them into our trust. As much as I tell clients, make sure you transfer your assets in there, it doesn't happen all the time. This can happen in a few ways. A business or bank account may have existed before the trust was created and never got transferred to the trust or never assigned to the trust. Or a new account, business, or property gets acquired later after you do the trust and simply is entitled correctly. It happens more often than people think, especially for entrepreneurs who are constantly opening new bank accounts, new entities, new businesses. It happens. And when it happens, a pour-over will acts as a safety net. It directs any assets left outside the trust to be transferred into the trust after death, so everything ultimately follows the same plan. In California, that process, having the pour-over will pour over the assets into the trust, will still require a court involvement. But when the trust is properly drafted, so if they have a trust and the pour-over will, there are often streamlined ways to bring those assets back into the trust without a full probate. This is why the language inside the trust itself matters just as much as having the will in the first place. Think of the pour-over will as your spare tire for your estate plan. Number 5 is absolutely critical if you have business partners. The buy-sell agreement. This is the document that answers all the what happens if questions no one wants to think about until it is too late. Imagine you co-own a successful design firm with a close friend. If you pass away unexpectedly, and there is no buy-sell agreement in place, your ownership interest doesn't disappear. It passes to your heirs. That could mean your spouse, your children, or someone with no experience in the business suddenly becoming a co-owner of this business. I've seen this exact situation nearly destroy otherwise a healthy company. One founder passed away, and his brother, who had no business background, ended up owning half of the company. The surviving partner was stuck in a deadlock, unable to make decisions or move forward. The business almost collapsed, not because it wasn't profitable, but because there was no plan in place. A properly drafted buy-sell agreement solves this. It lays out who can buy your interest if you pass away, become disabled, or just want out, and how that buyout is supposed to be funded, how we're supposed to figure out what the value of your share is, so that there is no arguing during an already a stressful time. In California, these agreements often use life insurance or other funding strategies to make sure cash is available when it's needed, instead of forcing a fire sale or taking a loan under pressure. And I don't want you to just think that this is for businesses with partners. If you own a business and you're the sole owner, you still need succession plan. Who's going to run the company if you're gone? Does it get sold? Does it pass to the family? Is it going to just, be wound down? A properly drafted buy-sell or succession agreement answers those questions in advance, and it prevents chaos. For entrepreneurs, this document isn't just legal paperwork. It's business continuity plan. It protects your partners, it protects your employees, your family, and the value you've spent years building. All right, so let's recap. Every California entrepreneur, no matter how big or small your business is, should have these 5 documents. Number 1, a revocable living trust to avoid probate and keep control of your assets. Number 2, a durable power of attorney to make sure someone can run things if you can't do it. Number 3, an advanced healthcare directive to protect your wishes and spare your family painful decisions. Number 4, a pour-over will to catch anything you accidentally leave out. And number 5, a buy-sell agreement to protect your business and your partners. If you're missing even one of these documents, you're taking a big risk, not only for yourself, but for your family and everyone else who depends on you and your company. But don't stop here. If you have protected your assets with the right documents, now you need to know how to shield yourself from lawsuits and unexpected risks. The next video is called Insurance versus LLC in California. Do you need both of them? I will break down exactly how these two tools work together or don't, and what every California entrepreneur must know to avoid losing everything they have worked for. I look forward to seeing you over there.